Live Dialogue.
Welcome back. Still had Factor 91.3 Nigeria info here in Port Harcourt. I'm Dio. 11 minutes gone past 5 p.m. and discussions continue at this time. On the matter we're discussing next, this was off our bulletin from earlier today. The Chief Judge of Rivers State, Justice Simeon Amadi, alongside Chief Judges of Kebbi, Cross Rivers, Anambra, Jigawa, and Imo State are expected to meet, this was from earlier of course, to meet with the Chief Justice of Nigeria, Justice Tanko Mohammed today. They had to answer questions on the controversial conflicting orders delivered in their various states. The CJN had in a memo demanded the records of proceedings in all the suits in which conflicting ex parte orders were given. Now, there are indications that a Chief Judge of Delta State has also been invited to join the other 6 Chief Judges to meet with the CJN tomorrow. Now, this may not be unconnected with the ex parte order which reportedly restrained the Governor of Yobe State, Mai Mala Buni, from parading himself as a member of the Caretaker Committee. Is the judiciary still the final hope or the last hope of the common man? What is the implication of this for the judiciary? There are question marks being raised about the judiciary these days. Can the judiciary still redeem itself? These and other related matters we're discussing this time. And joining me via phone for this conversation, Associate Professor of Public Law at the Rivers State University, former Chairman of the Nigeria Bar Association, Assoc branch, Barrister Ritchard Wokocha. Barrister, good evening to you. Welcome to the show.
Thank you, Barry, and good evening.
Now, let's start with this, on this note, the invitation by the CJN to these Chief Judges. Is it a good sign for the judiciary? Is it a good sign or is it a bad sign? How do you see it?
I would say it's not a bad sign.
So it's a good sign then?
Yes, it's not a bad sign and it's a good sign. The reason is simple. You will notice that Nigerians have been reacting to the resurfacing of what looks like irresponsible granting of restraining orders, centering restraining orders, especially interim, when parties have not been heard, making orders, removing persons from office, asking persons not to perform their duties and things like that, at a point when all parties have not been heard. And then when you begin to have that in a conflicting manner, clearly something serious is wrong. So since we are getting back into that season, preparatory for 2023 elections, I think it's only responsible.
Hello, Barrister Wokocha.
It is just the current of such conduct that tends to relocate the judiciary and bring the nation itself and its political system into relation. I think it's a good sign and not a bad sign. So
is it can one then say that the CJN has admitted, or the judiciary has admitted, that the judiciary in Nigeria is failing?
Well, you need to just go through the statements or the different statements of judges who are retiring from the Nigerian judiciary. Almost all of them talk about how well the judiciary has done, but it's almost always also talk of the need for us to take steps to stand the law into what I like to characterize as irresponsibility. Because whenever there is an abuse of office, there has been an execution of irresponsibility. So nearly all of them have always made one or two comments about the need to stem the dissent to that level of conduct. Judiciary is the most sensitive of the organs of government, and we cannot afford to find in the judiciary conduct like the conduct that are prevalent in the executive and the legislative now. It's not dangerous for society.
Now, Barrister, beyond talking to the chief judges of the various states that have been invited by the CJN, what really can the CJN do to stem or reverse this ugly trend?
I must say that in the federal system, there is not much the CJN can do as CJN. I am very convinced that the CJN has made this invitation and is holding this meeting in his capacity as the chairman of the NJ, the National Judicial Council, which has competence and responsibility to summon judges where necessary, to try judges or try questions relating to complaints about the conduct of judges, and to recommend for disciplinary action of judges. As you know, they also recommend judges for appointment. The judge is person nominated. They also recommend them for appointment, and they also have the power to recommend them for as chairman of NJC, but he has no capacity as CJN to summon judges of the other parts of the federation, like judges of the state, like Judiciary and Chief of Justice. So he's acting in his capacity as chairman of NJC. And to that extent, I think it is in order and there is much that they can do. Briefly, I can tell you up front that I expect that at least two things will come up in that meeting. And one of them would be expression of concern about the repeat of events that have happened in this country and that have been happening almost any time there's election around the corner, and that have been bringing the judiciary to ridicule, as well ridiculing the Committee of Nations. I am sure that concern will be expressed. I am also sure the second thing will be done, which is to say, look, the NJC does not find this funny anymore. And please pay judges in their jurisdiction that any judge who allows himself to be used to ridicule the judiciary will have himself to blame. His complaint comes to the NJC will take it serious. I am sure those are the two main businesses that a meeting of that nature between the head of NJC and chief judges of some states will deal with.
Let's talk about this contradicting orders being issued by the courts. One of the issues that have been raised in defense of these judges is that it's a systemic one in a sense that the judiciary does not have the equipment or the technology or procedures or processes that would help a judge in Zamfara, for example, to know that a matter has been addressed here or addressed in Lagos State, and that some order has been issued regarding that matter, such that if that matter were presented to him either by the same parties or even different parties on the same matter, he's not aware and may go ahead to, dole out to issue some order, ex parte or not, on the matter without being aware as to what's happened in Lagos State, for example.
And so they do not, even though they are also members of society who will read newspapers and listen to news items and get to hear what is going on. But the judge is not expected in his official capacity sitting as a judge to rely on anything that is not before him. Granted. So when a matter comes before a judge, yes, they have the responsibility to listen to the matter. But if they are being asked to deal with an issue that has been dealt with elsewhere, so unless it is brought to the attention of the judge can make an honest mistake by issuing an order in such matter. But that, of course, is subject to the fact that he has jurisdiction. Because nothing will explain the fact that a judge, for instance, a judge of the municipality of Abuja, can make an order over an issue that occurred in Rivers State or in Akwa Ibom State. That is definitely no, because there is no legal basis for even hearing that matter. He has no competence to hear such matter, not within his jurisdiction. So except for that, it is a matter that is within his jurisdiction. It is the responsibility of one of the parties to point out to the court that, look, this matter has already been litigated or is being litigated in the sister court in so and so place. And so steps have already been taken there. And then when that is brought to the judge's attention, it is expected that a judge, a power judge, will say, gentlemen, if this matter is already going on elsewhere, I think it will continue there. I have no, if it is a matter relating to order that has been made, I am not a court of appeal, I have no jurisdiction to review what has been done by a composite court or a part of composite jurisdiction or coordinate jurisdiction. And so, either proceed on or go to the court where your matter is and finish your matter. The judge who hears formally gets notice that a matter between the same parties is standing in another court, and he goes ahead to make others or others contrary to others that have been made in that other court, that is definitely acting out of good conduct.
Barrister, just a while ago you said, and I believe I've heard you say this several as well, and other lawyers also, that a judge is expected to hear every matter that is presented before them. And of course, a judge will deliver a ruling or give an order or deliver judgment one way or another. And numerous times we found matters before a high court, and judgment is delivered at the appeal court level. That judgment is upturned, and even at the Supreme Court level, the appeal court's ruling might also be upturned. And of course, it doesn't mean, and I've asked you this before in the past, I remember, does it mean that the judge at the High Court made a mistake, or does it mean that the judges or the justices at the appeal court made a mistake? And I believe your position, correct me if I'm wrong, has been, it doesn't mean that a mistake was made. Several reasons can be preferred, as to why judgments of courts at different levels might be different, while judgments are being upturned. So if we cannot say that a judge made a mistake in delivering judgment on a matter, even though that judgment is upturned by either the appeal court or the Supreme Court, can judges then be held liable for whatever orders they may give, or judgments or ruling matter at all, as has happened in these cases?
Definitely no. Where a matter has been decided at the higher court, that is either the Court of Appeal or the Supreme Court, and those courts, any of them, has made an order or has reached a decision in that matter, no high court judge sitting anywhere within the area covered by the Constitution of the Federal Republic, no matter over which the higher court or appellate court has reached a position, neither do they have competence to distinguish between the same facts and arrive at a different conclusion. They are bound by the decision of the appellate court, whether it is the Court of Appeal for a matter that hasn't gone to the Supreme Court or the Supreme Court. There is no competence in any high court, whether it is state high court, federal high court, or industrial court, any court of that jurisdiction of that level. There is no competence in any of them to say something contrary to what an appellate court or the Supreme Court has said concerning the same set of facts and between the same parties. None of them has the competence to do so.
You're welcome to join the conversation right now. The lines are open: 0817 923 0002, 0817 923 0817 923 0007. We are live on Facebook.com/Nigeria Info page as well, and WhatsApp is on 0809 0306416. Barrister, the statement or the saying that the judiciary is the last step of the common man is one designed, I imagine, to elicit a high level of faith and confidence in the judiciary. But with all that's playing out right now, do you suppose that Nigerians still feel that way? Do you think confidence in the judiciary is still high, or it's possibly maybe at an all-time low?
Every abuse of power, every abuse of judicial power, starts doubt and question on that time-long statement that the judiciary is the last group of the common man. Every absurd decision that does not stand in tandem with the language and provisions of the law lends credence to the fact that justice is for sale in that system, or is becoming for sale. So, when the events that are happening, the picture it paints in the minds of men is what we hear the ordinary Nigerians say, that justice is for sale. This man has gotten his own injunction, the other one will go to another case and get his own injunction. So it becomes a question of where you have connection, or you have friendly judges, or you have the war without to bend any judge. And officers are taking orders based on their contact jurisdiction. When that is going on unabated and without consequence, then you can be sure that people will shop for what they want, anywhere they want, and they will get something. Unless we make that conduct extensive on the part of those who are engaging in them as misconduct, it is the job of the government. So it does not help the image of the judiciary as the last hope of the common man. That only works and that stands when judges and courts return decisions that correspond with the law and show that no matter how powerful the parties are, it is the law that has been expressed. And what they have said is exactly what the law says, notwithstanding the trend and what has been the pocket of the parties before them are.
Oh, Rasta, pardon, Rasta, I do have to go for a commercial break right now. I must go for a commercial break right now. We've got also headlines at 5:30 p.m. Discussions will continue right after that. Do please stay tuned. Hard Flash returns in a bit.
Connect with your customers. Advertise on 92.3.
Headline News, Nigeria Info on 92.3. Headline News.
6 Palestinian prisoners escaped from most secure jails overnight. In business, African Insurance Organization holds annual conference in Lagos. In entertainment, Nollywood actor Ibrahim Suleiman reveals his friend blocked him from getting movie role. And sports, CAF postpones FIFA 2022 qualifying match between Guinea and Morocco following coup d'etat in Guinea. Those are the headlines. Details at 6 p.m. Contact our newsroom on 0818 90017. For more stories, visit www.nigeriainfo.fm. Thanks for listening. I'm Adedayo Elusakin. Good evening.
Connect you to the world. We connect you to the vicinity. We are Nigeria Info.
Listen to me. I said this is a real situation and the government has to do something about it. What are you trying to insinuate? All these people looting Nigeria's money?
This is Nigeria Info. In the heart of Nigeria. 92.3. We are Nigeria Info.
Information is a two-way thing. Nigeria Info, it's your turn. Let's talk.
And now, Hard Facts.
Hard Facts
With Dayo.
Welcome back. Still Hard Fact 9213 Nigeria Info here in Port Harcourt. I'm Dayo. 27 minutes to go before 6 p.m. We've got the major news at 6, and we're discussing what appears to be the CGN's move to sanitize the judiciary. My guest is John B. Furnace Barrister Ritchard Wokocha. Barrister, you're welcome once again. Hello, Barrister, you're welcome once again.
Thank you, Dayo.
All right, now, as regards still with the matter of the judges and the concern of the judiciary in the country, what's to stop erring judges from still issuing arbitrary ex parte orders or even delivering funny judgments? Is it possible to review these judgments of these erring judges or even the ex parte orders and possibly reverse them where it is found that their decision to positions is at variance with the law based on the facts that have been presented?
Well, let's begin with the last part of your question. Is it possible to reverse? Yes. An appellate court can. An appellate court satisfied that the judge's order was made without jurisdiction and clearly inappropriate, can forthwith on the application of an affected party, stay execution of that order, pending the hearing of the appeal of the substantive complaint before it, especially where it is concerned that such order was made without jurisdiction. So that's one way to address it. On the first part of your question, what can be done? How can we stop it? And how can they be discouraged? Because it's a misconduct, the proper thing to do is to make the misconduct expensive. Make judges pay prices that are high enough to discourage them. Prices that when they compare to whatever is what motivates them to act without jurisdiction and cause collateral damage to society. Make the cost of that misconduct more expensive than the benefit that they get from engaging in it. And that's why you discourage them. Because by that behavior, they are spoiling the image of all judges, including the very good judges. We have the bulk of them that are very good in the Nigerian judiciary. So we can stop them. We can stop that misconduct by making the misconduct expensive. I think that's what is done all over the world. What keeps people from doing what they ought not to do is the consequence of their actions. But wherever actions can be undertaken without consequence, you can be sure that people will exercise liberties that they do not have and carry whatever powers they have as far as it can carry them.
The lines are open once again. Join the conversation. Call 0817 93 0002, 0817 93 0003, and 0817 93 0007. We are live on Facebook.com/Nigeria Info PH, and WhatsApp is on 0809 030 6416. By the way, also live on YouTube as well. Just search for Nigeria Info PH on YouTube. Starting with Facebook in a moment. But Barrister, what's to stop? Still on the matter of airing judges, it has been alleged that some of these orders are being purchased, and you might remember as well that even some investigations were carried out recently to determine most corrupt agencies or arm of our polity or governance or system in the country. And every time there's, especially more recent times, where this research work or investigations are carried out, the judiciary always ranks somewhere very high. In some cases, even the highest as far as corruption is concerned. And it's largely, adjudged to be that way due to what has been alleged to be sharp practices, corruption, bribery allegations, or receiving of bribes or graft or gratification by judges. In the event that a judge decides to go to tread that path, and maybe receives a payout of sorts, to deliver judgment in one way or another, what does it matter what punishment comes afterwards? Because the erring judge has been paid already, maybe more than what the judge might even get in terms of retirement benefit. So, and it doesn't matter because, well, they're going to appeal the judgment anyway. So, I mean, can we really deter judges from doing this?
Hello, Barr.
Yes.
What's the question?
No, I'm saying in the event that, as has been alleged, that sometimes erring judges receive some kind of gratification or a bribe to deliver in certain judgment, to deliver certain orders in favor of certain elements. If that's the case, then what does it matter what sanction comes afterwards? Because the erring judge has received a payout already, which was the motivation for delivering that erroneous judgment or issuing some erroneous order.
So wherever evidence of that exists, then a crime has been committed. Whatever was received will eventually be recovered and lost on the part of the judge. And both he and those who acted with him in gratifying him in the gratification he received will be subjected to the criminal procedure of the Nigerian state. Definitely, you can be sure that the agency will take it on from there and ensure that he loses his job, in addition to being prosecuted for the crime.
Once again, join the conferencing lines are open and via WhatsApp on 0809-030-6416. This one via WhatsApp from Moses. Where a High Court judge overreaches his bounds and makes restraining orders, can't a court of coordinate jurisdiction adjudicate on it? Barrister?
Hello, Bayo.
Where a High Court judge overreaches his bounds and makes restraining orders, can't a court of coordinate jurisdiction adjudicate on it? Hello, Barrister, did you get the question?
I'm not quite getting your question clearly.
Okay. It says where a High Court judge overreaches his bounds and makes restraining and gives restraining orders.
Yes.
Can't a court of coordinate jurisdiction adjudicate on the same matter?
No. A court of coordinate jurisdiction cannot reverse it because only an appellate court has competence to reverse the judgment of that High Court. So a court of coordinate jurisdiction cannot. It cannot.
It doesn't matter how erroneous that judgment or order is.
It doesn't matter how erroneous that judgment is, insofar as the court that is acting is a court of coordinate jurisdiction.
What if the judgment or the order? What if the judgment or the order delivered by the court in error has a potential to cause some grievous, maybe irreparable harm?
Yeah, the best thing to do in that circumstance is to approach the court of appeal and swear out for the court to do something about it. They have to notice about danger or threat that order poses, pending the hearing of the substantive appeal that is before it. But the High Court, no matter how right or how clearly it is understood by the court that the previous order was erroneous, cannot address that order and correct that error from a court of coordinate jurisdiction. No, it cannot. Perhaps what can be gambled upon is on a subject that is not clearly that same one, or facts that are not clearly that same one, and a different question framed differently, addressing another aspect that is capable of arriving at affecting the substance of the one in which the erroneous decision is made. Perhaps if the question is different, but the parties are the same, the court may be able to distinguish between them, and if it is one that has jurisdiction, take steps to exercise jurisdiction. The danger with that is very often it can end up, unless the question is clearly a different question, it can end up making the order on what now constitutes the same question.
Got a question here via Facebook. Later wrote to me first sent this in. I heard there was a recent digitalization of the judiciary and court system. Is there no central information system that keeps judges abreast of recent or current judgments to avoid such contradictions?
Hello, Dayo.
A question over Facebook. I heard there was a recent digitalization of the judiciary and court system.
Yes.
Is there no central information system that keeps judges abreast of recent or current judgments to avoid such contradictions?
Well, as I said, the court ought not by itself to reach the decision that I think I'm aware that there is something like this or a case like this that exists in one other court. No, it is the parties that are to bring it to the attention of the court, not just by word of mouth. They should obtain either a certified copy of the order made or of the writ in the case, and then file that before the court. The court has to see clear evidence of the existence of the case we are talking about before it can submitize it and act with respect to it, recognizing its existence. But the court cannot, by radio news or by a television news or a newspaper publication, by itself raise that fact that, oh, I noticed or I am aware that something happened. So that question of digitalization and the possibility of information being available between courts does not even arise, because even if it's there, it's not enough. The party has to bring it to the attention of the court before it will be a fact before the court in that case.
All right, we got Francis on the line. Hello, Francis. You're welcome. Go ahead.
Good evening, Mr. Dayo.
All right, go ahead.
Yeah, not too long ago, there was a judgment given by a high court concerning about 150 prison inmates, who had overstayed the period, and the court granted them a release. And the state government appealed that judgment in another high court, the court of ordinary division. And the other high court stayed the execution of the other, the area court. So what does the barrister have to say about that?
All right, Russell, you got a question?
Do I understand the question to be the previous discussion we had, in which we talked about the judgment of a court in Rivers State and another one in Zamfara State, or where? That said something that affected the same subject. Is that what he's asking? It wasn't very clear.
Which matter are you referring to?
On the matters, recurrent matters on Rivers State, concerning Rivers State APC.
No, not that. No, he's referring to some lawyer who went to court here in Rivers State asking that some persons who have been incarcerated for prolonged periods of time should be released, and the court granted that prayer. And he says the Rivers State government went to court, a court of coordinate jurisdiction, and that court sat on that matter, even though I don't quite have the facts of that right now.
I don't quite have facts of a court of coordinate jurisdiction sitting and acting on that matter. What I know of is that the state brought an application before the court, asking the court to vacate the order it made, or to scale back the order it made. And I think I did hear that the court refused to do so.
Yeah.
If it's that matter concerning the order obtained over persons who were incarcerated without trial over a long time. I think that's the fact that in the public that I also had the privilege of knowing that was what happened. The state did not go to a court of coordinate jurisdiction, and they did not get a contrary order. Those people are still, they should still be enjoying the freedom. If the first judgment has been implemented, they should still be enjoying the freedom that the court granted them.
Customers Udame Barr Facebook goes, the slogan, the judiciary, the hope of the common man, is then not now. The judiciary is the hope of the elite and political class now. The politicians and really bought off the judiciary. That's why there's so much injustice in Nigeria. Corruption has completely taken over the judicial system. That's why our country is like this. Ned Aguma on Facebook goes, at least this is the first time in the history of Nigeria that the chief judge is invited, chief judge is invited by the CGN in this kind of matter. The judiciary, especially River State, has turned itself to a shopping mall where you can go any day, anytime to buy some injunction included in the night. How did we get here? Prince Hakeram goes, if nothing is done to put an end to this indiscriminate sales of justice in Nigeria, I wonder what will happen to Nigeria after now. Once again, lines are still open. Call 0817 93 0002 or 0003 0817 93 0007 also. Barrister, 2023 is approaching. It's around the corner. Expectedly, or we might say that our honorables and excellencies and politicians might be on a shopping spree, maybe even now or very soon, to get all kinds of restraining orders and injunctions and ex parte orders and and the rest of it. Are we certain that what's played out in the past and what appears to be played out as well will not plague us still come 2023 when, once again, expectedly, the politicians will go on a shopping spree for all kinds of ex parte orders?
Hello,
Hello, Barrister.
Yeah, there is no certainty that what happened in the past cannot happen again, unless we manage to stop the reoccurrence of that thing. And the way to stop it, as I said, part of it is what the NJC is doing now, through the chairman of the NJC. If that succeeds, if the objective is achieved, then you will likely have less of the occurrence of that kind of conduct. But unless something like that or something more serious happens to discourage those who will be led by whatever inducement to engage in such misconduct, we can be sure that it will be business as usual.
In your personal opinion, can the judiciary redeem itself completely?
By stopping continuation of that, and two, by making those who have engaged in conduct that are misconduct, conduct that are considered by the law to be misconduct, making them pay, and issuing strong statements to that effect. When citizens see that happening, when they see a judge that abused his jurisdiction or his powers, when they see him pay for it, and they hear the judiciary make strong statements about that, it will be clear in the minds of the common man that the judiciary is doing something about it, and that the conduct of that man is an exception to the conduct of the judiciary. That in itself will prove that it's an exception to the conduct of the judiciary. And people will begin to have their hopes restored that that conduct is not the norm, but it's a negative exception that even the judiciary does not tolerate or like. But if they keep quiet and people are able to do that, judicial officers are able to do that and get away with it, then they are buying into those misconducts, and citizens will have no option than to believe and accept that that is the new normal, and that it is the culture of the judiciary to sell judgments or sell orders.
And why what some of the Nigerian judiciary is run like a drug cartel. Cyber cafe injunctions and ex parte orders can be purchased from the shelves. Why can't those SANs who are filing frivolous cases in different courts be sanctioned and have their license withdrawn? Even when judgment has gone against them previously, instead of appealing to a higher court, they will go to a court of the same jurisdiction in a different state to shop for a favorable judgment. The NJC is a union of corrupt judges. That's why they can't sanction those corrupt judges issuing out fraudulent orders. That's in relish. Barrister, how about the lawyers who filed some of these dubious applications and equally receive dubious orders and rulings of corrupt judges? Should these lawyers be sanctioned as well?
Oh, certainly. The judges who are presiding over the matters have competence to make scathing statements about the lawyers who have engaged in conduct and apply for prayers that are clearly unlawful and seeking to rope in the judge or the court into unlawfulness. They can condemn that with strong point, with a stronger statement. And where they feel that it calls for more than just strong statements, they can go ahead and recommend to the disciplinary committee that those matters be looked into, and they can be done. So when that is done, senior lawyers who are involved will also adjust. Petitions can also go to the NBA from parties that have suffered from the misconduct of those lawyers, and the NBA can also activate its disciplinary process against those lawyers. So something must be done about it. It's a two-ended thing. The judges do not originate the cases. So if we are trying to correct the judges, we must also do something to send a strong statement to lawyers who engage in it that those practices are considered malpractices.
Well, I guess we'll have to wrap up the conversation on that note. Well, before then, I do have a few comments here via WhatsApp as well. Good evening, Adedayo and Prof. We have instances where when a superior court, in giving a ruling that upturned a lower court ruling, especially a high court ruling, criticized the judge or judges, and in some instances, the lawyers, doesn't that serve as a basis for NJC to investigate that judge or judges, and perhaps stretching it, doesn't it even give the NBA reasons to investigate professional misconduct of that lawyer or lawyers? That's some text. Barrister, a quick response to that.
The party who suffers from the conduct of that judge, that should encourage him to complain to the NJC. But the appellate court will not on its own, and in hearing an appeal, originate a case for the disciplining of a judge who erred in what he did at the previous time. You remember the Supreme Court has made strong statements about conduct of the Court of Appeal or some judgments of the Court of Appeal in matters arising from Rivers State and relating to Rivers State sometime in 2018 and 2019, etc., etc. So there have been such things, but those statements will not in themselves originate a disciplinary proceeding. A victim will have to complain by filing a petition before the NJC, and then the NJC can investigate. And to file that petition, you have to have your facts and your evidence.
We must wrap it on that note. Thanks for joining the conversation, especially my guest, Barrister Ritchard Wokocha, is Associate Professor of Public Law at the Rivers State University, also former Chairman, Nigeria Bar Association, Assoc branch. Barrister Wokocha, many thanks for your time.
Thanks for having us today.
Got a commercial break coming up right now, and the major news top of the hour at 6 p.m. If you missed out on any matter discussed on the show today, I'll take your thoughts on those issues during the open season segment after the major news. Do please stay with us. Hard Facts returns shortly.